Well, hello and welcome to that favorite hour of the evening where we bring one topic, go in depth in it. You just sit at home, relax, and get educated and informed on it. And today, one such thing is the passage of Right to Information Bill, which has suffered another setback. Well, the minority is saying that if you haven't given us the handing over notes, we're not going to go ahead and do any government business in Parliament, and part of government business in Parliament will be to pass this bill. This is one bill which indeed, as far as corruption and transparency is concerned, it would really help, because at the moment you can walk into anybody's office and demand an information and they can simply say no and it won't be given to you. However, this was a bill that was going to come, so as media men, we could write to any institution, any government agency and say, look, I demand to see the contract between yourself and that foreign entity, and within a stipulated time, it should provide it. One of the things that would happen is that people would then be very wary, sit up straight and make sure they do things more pro-Ghana than pro their party or themselves. 10 years. Back and forth. So we're all hoping that since this bill has been through Parliament and many T's have been crossed, many I's have been dotted, they were just going to give it to us as a Christmas and New Year present before the 7th Parliament sits. Guess what? It looks like it's not going to happen again. And per parliamentary technicalities, if it doesn't happen, you start all over again. You can't just hand it over to the next Parliament and say, there you go, sign it. You have to start afresh. It's taken us 10 years to get here. Are we going to start afresh? And why is it that the minority is suddenly not too keen about it? My name is Nana Sakwa. This is PM Express. And when I come back, we are going to find out why with some really fine vocal gentlemen. Don't go. Well, thank you very much for staying. And as I said, Right to Information Bill, which is suffering another setback in Parliament. With me in the studio, I'll start from my immediate left, Alexander Kwamina Afenyomakin, MP for Refutu. You're welcome.
Thank you.
Let me see.
I hope you're good.
I'm very good. We've had our qualms already, so we are now buddies. And then in the middle is Suleiman Abrahima, Executive Director, Media Foundation for West Africa. Sule, you're welcome.
Thank you very much.
And then my brother George Lowe, who's the Vice Chair for the Parliamentary and Constitutional and Legal, the Subcommittee for Parliamentary, Constitutional and Legal Matters. George, you're welcome.
Thank you, Nana.
Very good. So I guess it's fair if I start with Alexander Afenyomakin, since now he's the minority, MPP, soon to become majority, but they are the ones kicking off. So let's ask why they are throwing their toys out of the pram. Alexander, you're welcome.
Well, Nana, I appreciate the opportunity to discuss this matter, and I would do so without any partisan consideration.
I'll be very glad, particularly so that we can really understand, because I am a bit...
Now, let me start with this general preamble. You see, where we agree on rules of engagement and we agree that there are procedures for doing an act, it shouldn't be a disturbing matter if any person or group of persons invoke that rule. If at any point we want to oust that, then we should make it known. I have a problem where somebody would say that let's do it the right way, and others will say no, it is not, let's go ahead. I can give you instances where people have sidestepped procedures and coming back later on realizing that we've gone round, we need it back. A typical example, without going far, is car power. We say come to Parliament for approval. They say we don't need parliamentary approval. Now you come back, you want to invoke Parliament jurisdiction under Article 174. You want tax waiver. When Parliament has not seen the parent document, there's a project implementation agreement, which has not been cited. But embedded in that, you need to have a tax waiver. Now, coming back home to the matter before us, the minority MPP is not saying that we do not want this bill to pass. The minority is not saying that this bill will not enhance our democracy and relationship with the media and the right to information, government information, which, as we see it, is not forthcoming when you want information for public discourse and to enable transparency prevail in our dispensation as we find ourselves. What we're saying is that let us anchor whatever we're doing on the Presidential Transition Act as amended. Now, without belaboring the point, if you look at Section 6 through to 7 and 8, you have handing over notes. It tells you what ought to be done and all that. The contention of the minority is that, look, we want this to be captured in the handing over notes. The learned Attorney General has prepared a handing over notes, which talks about what has been done and the progress of work to be done up to the 6th of January 2017. Are we able to say that the learned Attorney General has captured that in a handing over notes and that we know the state of affairs? Has the learned Attorney General's office complied with the provisions of the Transition Act? All the minority leaders sought to clarify was this point that I've just stated. But of course, with the greatest respect, Mr. Speaker was of a different view. Now look, we've had an extensive consultation on this matter. This matter is already before the House. Let's go on with our normal business and let's deal with matters later. But our side was of the view that, look, yes, Mr. Speaker, we agree with you. To the extent that the bill is before us, in normal times, we will continue to do our normal business. But we are in a peculiar situation. Transition. Certain things must be properly done. And these things are covered by law. The law provides that A, B, C, and D must be in place. And of course, the House, Parliament itself, must have records, give the state of affairs. Because anytime we rise, Mr. Speaker, in his closing remarks, would summarize activities for that particular sitting. So we need to know per the procedure and per the provisions of the law. So we did not, I just want to put it right, that Parliament, by way, I mean, not Parliament, the minority side did not kick against the consideration of the bill. The minority side raised an issue regarding the state of affairs with respect to the Presidential Transition Act vis-a-vis the work of Parliament. Because today, for instance, before I came, this paper, for instance, was laid. This is something that the Finance Committee, we had rejected, that they should go and do proper work. We are rising tomorrow. Then, all of a sudden, a financial agreement of $84 million is brought before you. You want to ascertain whether the Finance Minister has actually stated this in the handing over note and has even indicated that there is this to be considered by Parliament. If you raise this, it's a legitimate question, and you have a legitimate expectation that having raised it within the context of the rules of engagement, same will be considered, rather than you being younged off. That, well, I don't care, and then you play to the media gallery to create the impression that, oh, well, the majority wants to do business, the minority is kicking against. I think any impression so given in that manner is so done because to court
because of
the
time,
media's whatever, and also it's being done in bad faith.
Because of time, let me bring George in here now. George Lowe, May Councillor approach the bench.
Well, thank you, Nana, and good evening to our cherished viewers. And I'm listening to my brother and friend Alex Ojamaki, and I think that he's made points. Let me begin by saying that, well, the minority may be entitled to that opinion, but we don't share that view. First and foremost, we must recognize that we are governed by rules and laws in this country. The master law is the Constitution of Ghana. And in that law, there is separation of powers. There are 3 arms of government, and yet there's also a fusion, if you want to. Now, you see, the matter before us is very simple. There is no business before Parliament that deals with the transition process. Parliament had unfinished business. We adjourned the last Parliament synod with work in progress. We have come back. And the RTI was one of the major works in progress. We have come back, and it was the Speaker's intention, and indeed the intention of the majority leadership, and of course the minority leadership, I would say, to finish the RTI before the life of this Parliament comes to an end. In that process, for us, it came as a surprise that suddenly the issue of transition, which is not before the House, which has nothing to do with the RTI, which has nothing to do with the business we are doing on the floor, becomes an issue that, to the extent that the minority said they may not want to participate, in business on the floor. But I found it very, very, very interesting, because indeed on day one, they didn't, when we started, and I had the privilege of doing the clause by clause amendments on the floor. I've done 53, I've done 54, and we had come almost at the end of 54 when one member from the minority side raised the issue of quorum. He didn't raise the issue of transition. Handing over notes did not feature in this argument. It was simply a matter of quorum, and we tried to get him to go down because we've done several important bills in consideration, even when we didn't have a quorum. And it was a practice of the House. There are times we don't have a quorum, but once we are doing consideration, we overlook, because we want work to progress, we overlook the issue of quorum. Until even sometimes when a member raises it, we are able to talk, or leadership is able to, ask the member to as it were, chill, so that work can go on. So I was surprised that the following day, the issue of transition and handing over notes coming. But really, 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 if you look at the transition act that they are using, together with the amendments, what is the relationship with handing over notes to the work of Parliament? Must we go and read all the ministries, find out what they stated in handing over notes before we decide on the work we do on the floor? Procedurally, no. Conventionally, no. Because, Nana, it's very simple. We've asked ministers to bring handing over notes. When they bring it, the transition team has work to do. They need to sit down and go through them. Where there are issues to raise, they raise it there. And that is why there are people from both sides considering the transition together with the handing over notes. When you want to mix that with the work of Parliament, then you are being unreasonable.
Let me come back to Alexander before I go to Sule. I'm still trying to figure out the link between the transition and the passing the bill. I can't seem to get the link.
The person who laid that paper, who the sponsor of that bill, is the Learned Attorney General.
Okay.
All right.
Yeah.
Now, our issue was very simple, procedural. That can we be sure of what we're doing vis-a-vis the handing over?
As to whether the Attorney General has written in her notes that I've given this bill to Parliament?
It is her ipso facto responsibility under the law. The law says so. May I, with your leave, read what it says? It says, under section 6.3, the handing over note shall reflect the accurate development which have taken place during the tenure of the office. the tenure of office and the projections of development to take place before the end of the full tenure. You get my point? If somebody asks this question, that, oh, can we find out on this? The person has not said that I do not want to participate. In fact, I was in the house. I remember that when the minority leader raised this matter, the majority leader, who is the leader of the house, agreed with him and said, look, let us suspend sitting for 30 minutes and do further consultation on the matter. So I think I need to put it in a proper context. We did not object to the consideration of the bill. The public must know this. And the majority side did not disagree with those concerns raised by the minority side. They in fact agreed that let there be some consultation. Then it means that what the majority felt on the floor of the House was that there was merit in the issues raised, except that the Speaker looked at it differently. So I don't see any point of this.
But Nana, just because he's talking on the point of law, you see, let's be very candid. You see, the confusion we are creating is needless. Look, the law, the amendment, that bill, the amendment, and I have the Presidential Transition Amendment Bill. You see, the transitional notes you are talking about, the form that you envisage that it should be, is not even before us. It says that what? 12A, the minister responsible for justice may, by legislative instrument, make regulations to prescribe the form of handing over notes, the form in which it comes.
But with respect, without cutting you.
Yes. Yes, no, I'm telling you.
With respect,
yes.
But has that been done?
That is what I'm saying, that you do not... So it is wrong for somebody to even sit down and decide that A, B, C, D, E, F, E, G, H must be in that document.
Okay, you interjected me on the point.
No, but I'm just So don't go there. The law itself says that it is that form must be prescribed through legislative instrument.
Hold on. You see, you are in government. I think it is even brought in a new point for us to consider. They are in government. We passed this act. This law was passed in 2012. We did this amendment somewhere July, I think. Now, as we speak, the minister who has been given this mandate to come up with a subsidiary legislation to regulate how all these things, to specify the operational aspects, you've not done it. All right? You've not done it. The law allows you to. And there's a condition, the proviso, that you may. So it means that if the minister has not done it as we speak, then maybe an argument will be that I do not think it is reasonable to exercise the discretion now, or I don't think it is necessary. I'm trying to be the devil's advocate here. But you have not done it. In principle, there's no subsidiary legislation. So who are you to blame? Yourself. All we are saying is that by the law, we're supposed to see the handing over note, the progress of work. If the provisions are there, we didn't amend 6.3. And by the way, your side did not disagree with those concerns raised. The only thing was that the head of the assembly, Mr. Speaker, had wanted to progress in a certain way. I don't think we have to belabor the point. But my brother raised a point that maybe he took it lightly. But somebody may come up with a constitutional matter that sometimes we're able to forgo issues of quorum. I am unable to agree with him on that. Quorum is a constitutional requirement. I don't want anybody to get the impression that, oh, Parliament sometimes does work without quorum. Because a constitutional matter, and if it goes for any interpretation at the Supreme Court, and they would want to rely on some of these submissions that a member said that sometimes they're able to do business without quorum, it may be a problem. As far as I know, there is no certain, unless there are some examples that he is privy to, but as far as I know, there's no such thing. quorum is necessary for us to proceed, and it's always like that.
Let me bring Sule in here. Sule, I mean, here you are, Media Foundation. You're waiting for your right information bill so you can get to work, and the legalese are at work. You know, so I mean,
well, I think it's great to be here and to be sandwiched by two respected honorable members, and I must congratulate them for winning their seats to represent their people back.
I didn't contest.
Oh, you didn't? Okay. But of course, you've been an MP, so having represented your people and in the great House of Parliament, and I know Honorable Markin is returning to the House. Now, so far, listening to both honorable members, I think that I'm not a lawyer, they are both lawyers, but I haven't heard any of them say that there is a particular law that prevents the Honorable House from considering the RTI bill. What I'm hearing is that based on this condition or that condition, we may or we may not, you know, avail ourselves in considering the bill. But if I heard Honorable Markin right, it seems to me, or my understanding is that the minority side feels that it is right, or you know, by law, that at this stage they should have had some handing over notes that would inform them of what has gone on, what is to go on, and then what the projections are. I think the most interesting thing about that is that it still boils down to the same access to information. I think what the minority wants, or what they are seeking, is information from government. What is the handing over notes? We want to know what has happened. We want to know what the projections are. And by extension, that is what we have been talking about all the time, that democracy is about the participation of the people. And it is because we cannot bring all the people from Ifutu to Parliament to make laws for us. That is why we say elect one person. It is in the same vein that Honorable Low's people have, you know, elected him, Novdai, to represent them in Parliament, because we cannot all be there. But in the process of governance, it will be good that we have opportunities that allow us to also engage with you and engage with the relevant authorities at the local level. And I think that one most fundamental basis for engagement is information. And it is not about information that honorable members or ministers or a government want the people to have. What is important is the kind of information that the people themselves want. And all we are talking about is, let's have a piece of legislation that makes it possible for citizens to assert that right. That makes it possible such that if I want, maybe as a constituent of Honorable Afenyo Markin, I can write to him and say, Honorable, I want you to disclose or to let me know how you spent your common fund, your allocation of the common fund for 2016. I want to know how you did that. At the moment, that is not what is there. We want a situation where a local person can write to the DCE or MCE and say, I want to have a copy of the budget, and I want to know how you spent last year's budget. We want a situation where by now, as a citizen, I should be able to write to a minister and say, I want to know how much contracts you've signed this year. I think as citizens of this country, we are being treated unfairly if our honorable members at this stage would want to resort to technicalities, because that is what I am feeling, that it's about, there is no law preventing us from engaging now, but technically we want to receive handing over notes, we want to go by the Transition Act and so on and so forth. But I think that the process of governance is continuing. All public sector workers, in fact, including the respected honorable members, would not say that because we are in transition for December, they are not going to be paid. I'm sure that governance is continuing. Processes are ongoing. And therefore, if we have the opportunity to give to the people of this country that single piece of legislation that would make their participation and engagement in the governance processes more effective, I think that they will do us good. And for the minority, I think Nanado, I've heard, is going on a thank you tour. I mean, he's in my part of the country today in the Upper East region. I think the most great thank you that he can offer, or the minority can offer to the people of Ghana, is to support the process for the passage of this law, so that at the end of the day we say, well, we are coming to power, but we've given you the opportunity to question us to seek and receive whatever information that you want on governance. At this stage, I think that it may have been the majority side who would have maybe played some drawbacks. But I think that Honorable Macken and his group, as well as Honorable Low and his group, will do Ghanaians a lot of good if they come to a compromise to have the bill passed as quickly as possible.
Well, let me I'll bring you in here 1 second, but the Act 845, the Presidential Transition Act 2012, the 3 says the handing over notes shall reflect the accurate development which have taken place during the tenure of office and projections of development to take place before end of full tenure. 4, the original and 5 other copies of the handing over note shall be presented to the Administrator General appointed under Section 8. 2, not later than 30 days before the date of the presidential election. 5, the handing over notes may, in addition, be in electronic form. Availability of the handing over notes. 1, the Administrator General shall make available to the persons elected as President the original copies of the handing over notes. 2, of the 5 other copies, A, the Administrator shall retain 1 copy, and 1 copy shall be sent to, respectively, to Parliament, the Chief Justice, the Council of State, and the Public Records and Archives Administration Department. I'm going to take a quick break, and then when I come back, we'll find out, is this what's stopping our bill from coming? Don't move. Well, I told you it's going to be educative and very, very informative, and we're just trying to find out why it is that the Right to Information Bill cannot be passed so that you and I can have a good Christmas and a very, very happy New Year from the Parliament House. That could be the best ever president we would get. But it seems as if it's hitting a hurdle. But just before I read the act before we go, so I'm coming straight to Alexander Macken to find out, is this the main problem because all these haven't been adhered to?
And I've listened to my brother from civil society, and I disagree with the aspect of his submissions where he lays emphasis on the technicality as a tool of delaying the bill. I disagree with that. And I ground this on the fact that we ourselves, as a nation, by our laws, have provided for certain procedures to be followed. And technicalities are part of it. For instance, as a lawyer, this is my senior. If I draft an affidavit, if I'm with him in chambers, and he says, Afenyo, draft an affidavit, and I look at it, he looks at it, he would want to see the ingredients that are supposed to, how an affidavit is supposed to, the form is supposed to take. Similarly, if a junior comes to me for training, I would say, you can't draft an affidavit for it and say, I, Kojo Mensah, of house number KB/4, Accra. You are wrong. If you go to the Supreme Court, Justice Eni Yabua or Chulek Badegbe will tell you that no, that's a defective affidavit. It's technicality, but it is part of the rules of engagement, the procedure, to make your application meritorious, to properly lay it before them. So having made that submission, I want all of us to be clear in our minds that it is not in anybody's interest to delay this. Nobody is delaying it, but we should ask questions. I have a problem in Ghana where you would want to ask questions and somebody says, oh, you are asking too much. Look, today, I saw the CI 103 as lead. The president-elect, Article 63(9) provides for the gazetting, of the results. And the way it's been drafted, I said, no, this is not a legal instrument. It's a declaratory instrument, a legal instrument. The way it is, should we allow it? And I raised it on the floor of the House. I didn't get the full audience of Mr. Speaker, but I will insist tomorrow if I get opportunity to raise it. Somebody may think that Afenyo is being petty, but Any law student tomorrow, anybody looking at how the thing has been drafted, want to look at the standard. Has it been drafted in a manner acceptable in law? You can't say dated the 12th day of December. You will have to say dated this. Senior, is that not how we're taught? So I am only pleading. Yeah, the politics aspect of it is there. But we are in the house. The house would finish its business on the 6th of January 2017. Do not have any worries. What was raised on the floor was not to unduly delayed. We only asked that, are we complying with the Presidential Transition Act? You know that in the law, if the president is re-elected, the rules are different. The provisions are different. If it's a new party taking over, the provisions are also different. So if we are asking questions, now we are working. And I've cited this example. The president still has a mandate to bring a loan agreement for us to consider. But should we just take it as it is? No. We have to, agree on certain things. So I would plead for patience. Both sides of the house agree that we need to expedite action on this. By the way, the delay in the passage of this bill is not the cause of Parliament. It's not Parliament that delayed it. The bill, when it came, civil society, I don't know about his outfit, but the civil society made a lot of input. Come change this today, change that tomorrow, change this. You, the media, played a role. You wanted a certain amendment to be made, and the committee had to consider it. So it has been a participatory work. It's been an all-engaging job.
10 years.
Oh, I am talking about the form as it was laid, per the memorandum attached, right to Information Bill 2016, when it was gazetted. If you look at it, I'm not talking about when the whole idea was initiated. I'm looking at the date. It only came date of after all the amendment input from civil society. We're talking about October 17. This is the thing. We are in December, so technically, or as a matter of record, 17th October, 17th November, 17th December. This has been in the house for a little over 2 months. So it shouldn't be the case that it's been lying down and nobody wants to deal with it. You get the point? Mm-hmm. So it must be appreciated in that light, so that the public will not be misinformed. The public will not think that, oh, the NPP does not want this law to pass.
I think the public's idea is that, look, they've heard of this bill since
that is right.
Yeah.
If they said, oh, we heard of it long ago, why has it delayed? I am saying that all concerns needed to be factored. And the bill, the current bill as we have it,
came to the House 17th October.
Which is before the set Parliament.
Assuming the Attorney General hasn't finished the handover notes for one reason or the other, maybe.
What will change? You are taking me to law school when they say.
Assuming she hasn't finished.
What would be your advice if? Well, let me be blunt with you. Mm-hmm. If the Learned Attorney General's office has not captured this in a handing over note, I'll be surprised. And I would wonder why same is not captured. I would be surprised, and I would wonder. And the question is whether or not it would affect, would mean that we would encourage her to effect a certain change, mutatis mutandis, to enable us to proceed.
So would you proceed before, or she has to move before?
No, are we not talking of law? We are not talking technicality. Nana, you are raising a legal question. Yeah. You are saying that if the Learned Attorney General breaches this law, what will be our position? Mm-hmm. The Learned Attorney General has breached the law. If she has breached, you are putting it in perspective. Mm-hmm. In the context as you want to put it, if the Learned Attorney General has breached, it affects the whole, doesn't it? If she has breached, why should we proceed when there's a breach of the law? You said that we should overlook it.
No, the Attorney General has got millions and millions and millions of cases.
Oh,
Now
but this
she's
is an important one.
yeah, no.
She brought it.
Just
She
as-
brought it.
I know. In her handover notes,
Yeah.
she probably says,
She
"Look,
overlooked it.
I took Wyoming to court. I took him to court. I did this. I did that. I did this." But somewhere in the
She forgot.
She's forgotten.
Inadvertent.
Yeah.
Okay, then we'll draw her attention that, oh, can you get this?
So, but what are you going to do? Go back, go through all her notes before you.
Oh, no.
Nana, you see, Nana, it's very basic. I mean, I don't think that we are dealing with a big issue here. The Attorney General, year on year, presents a report to the Constitutional, Legal and Parliamentary Affairs Committee about, even when she's bringing a budget, she doesn't only just bring a budget, but she tells us the things she has done and what she intends to do. So it's basically the same polished up thing. But you see, we are raising a fundamental question that we cannot even answer. Has anybody said that the Learned Attorney General hasn't submitted her handing over notes? We were all there when our former senior colleague, Honorable Safo Mafo, took delivery of handing over notes from the Administrator General. And they actually said that they had seen and they were satisfied with it. Now, then we go on to say that in the law it is said that the Administrator General must make available some of these things to various quarters. It leaves the domain of the Attorney General. She has submitted her notes. And from what we know, as at last week, was only the Office of Government Machinery that delayed. All other ministries have submitted their handing over notes. So we cannot even be talking about the Attorney General not submitting her handing over notes. What I am saying simplicity is that, look, the transitional team as so constituted is made up of both sides of the government. Okay? Thankfully, we have a system now where we have only the minority and the majority in the incoming government. You don't have any other party mixing them. Each side has the law has spelled out who should be on it. People have been appointed to just ensure that the right things are done. At that level, they haven't complained. I am saying that this is not one of the things where, even when the handing over notes gets to Mr. Speaker, photocopies or copies will be made available to every member of Parliament. No, the law doesn't say so. It is just remitted to the office of the Speaker for record purposes. So I think that we'll be pushing the bar too high if we are saying simply that we haven't seen the handing over notes, so we will not work on the law. I insist that whatever we do on the floor of Parliament, in terms of the business of the other people, has nothing to do with transitional notes and handing over notes.
Let me come back to you.
Nothing whatsoever. I am sure that if we cooperated and we gave attention to the right to information bill as we've given to other bills in the past. We've stayed in Parliament till 12 midnight passing loan agreements. We've stayed in Parliament up to 12 midnight passing other laws. I believe that together with the minority, we should be able to do this one.
From a layman's point of view, assuming the Attorney General brings her notes and the RTI is captured in there, but we don't see Gitmo 2, we don't see Bass branding, we don't see Wyoming in there, are you going to go and tell us, well, it's not complete and therefore go and complete it before we pass this bill, or you just want to see RTI in her notes?
I think I did not belabor the point. Our views are very clear that has there been compliance with the law on transition? Simplicity. It's just it wouldn't take the matter as raised. Even the majority bench or the majority leader agree that, all right, there's merit in this matter. Let's suspend sitting for 30 minutes. Let's put our heads together and proceed. So I don't want us to overstretch the argument. We know, as a matter of fact, from the submissions by my senior brother, that the Learned Attorney General has submitted a handing over note. Okay? So what next? Tomorrow we are sitting. I'm sure the necessary consultations have been done. I'm sure the House itself has its own way of handling this matter. Let's go back to the House.
Let me bring you.
As the right thing been done. Then we proceed.
Suleiman, let me bring you.
Yes, I think it's getting quite interesting. Again, I'm not a lawyer, so I wouldn't want to go into the legalese of issues. But so far, I'm yet to be convinced if there is any provision that has been read here or any legal document that has been read here that suggests that in the event we find ourselves in a situation such as we are in now, Parliament or one side of Parliament may exercise a discretion of staying out of their normal business of lawmaking, because all of us are made to believe that the core business of Parliament is lawmaking. And I'm saying that I'm yet to see any legal provision that says, for example, in the event the Attorney General fails, let's assume she fails to submit that, then one side or Parliament as a whole group may exercise that discretion of saying, therefore, we are not going to carry on with our core business, which is lawmaking. Now, the other point is that I made a point earlier, assuming that the minority's point about we requesting for the handing over notes is what is the case, and let's assume it is legitimate. I think that we are looking at a situation where, because a group of parliamentarians have the power to say, we require this information and we must have it. But what we need to also consider is that the supreme law of the land, which is the Constitution, makes that express provision that citizens are also entitled to information. And the people, the citizens who elected you to be in Parliament are saying that, look, we also are seeking you to act in this way so that we can exercise that fundamental constitutional right that we have. And for over 10 years now, we have had a law go to Parliament, come out, go to Parliament. It's true that, yes, civil society has played a role in the delay. But the role that civil society has played is essentially saying, well, we think that the law as drafted or the bill as drafted would not help the cause of citizens when it comes to access to information. But the point is, look, Liberia has passed their access to information law. It didn't mean that civil society did not engage in the process. Nigeria did it. And I know the big role that civil society played in terms of inputs, in terms of saying, we don't like this, we think this is not good, and so on and so forth. Cote d'Ivoire, despite the challenges they've gone through in terms of post-elections crisis and so on and so forth, their parliament has passed the right to information law. And so many countries, you may say, is it working or it's not working? But that is after the fact. That is after we have the law. The most challenging thing is what perhaps was going on with the discussions that we had off air, that if we don't have the law passed in the life of this parliament, what it means is that we're going to start the whole process afresh. Because it's not like we are saying, oh, but why? If they don't pass it, wait. On January 7th, the new parliament is there. So they just hand it over to them for them to continue and pass it. That is not what it is. If it doesn't happen, it means that we get to ground zero to start the whole conversation again. And I believe that honorable members know the process, the difficulties, the engagement, civil society, we are meeting here, we are meeting there, the parliamentary committees are working and so on. And it's quite a tedious work, I believe. At some point, MPs were complaining about the number of amendments. You know, at the beginning, over 1,000 or so amendments. This evening, I heard the deputy majority leader say that, look, all we are left with is just about some 40 issues. Some of them are just dots, put a dot here, put a full stop here, put a comma here, and so on and so forth. So why wouldn't our honorable members, our representatives, do us the favor? Well, let me even call it a favor. Technically, it shouldn't be, because that is why we put them there, to represent our interests and to do the kinds of things that would help us engage in the governance processes. And here we are being denied, or we've been denied for over 10 years.
Yeah, let me just make it just for information purposes. You see, what has even enhanced it was that, you know, at the point when we saw that the amendments were so many and that it was going to be obvious that we will not be able to finish, we asked the Attorney General to withdraw. So she withdrew. We looked at the amendment. We called the relevant people who raised that amendment. We discussed with them. We call it winnowing. And we corrected as many of them as possible. And then left those that we thought that the whole House should engage. And then she relayed it. That's how come that it was really just 3 months ago. She relayed it. So you could have cut the amendments to barely the minimum. You know, and that is why we are saying that we needed to pass it. And that's why the majority leader was even talking about cutting financial loss. As vice chairman of the committee, you can imagine the workshops I've attended, the things that I've learned, the institutional memory I'm taking away from the House. And a new person comes and there's going to be a new chairman of the committee, there are possibly going to be new members who have nothing, who have no knowledge of RTI, and therefore would also need the same level of training. If they also do it at the end of the 4 years, so you are training people with resources, and you are not getting results because of all these things that are going. That's why we are saying that whatever it takes, we should be added in as a Parliament of Ghana, or the Parliament of Ghana, and ensure that this.
Unless, of course, there's any law that says without the handing over notes, Parliament must cease.
On the issue of the effect of technicalities, okay. Let me just refer you to a case, Supreme Court decision, very recent. Republic vs. High Court Criminal Division, ex parte Franzata. A judgment was delivered on the 6th, in July 2016. All right. Now, let me go to page 7. I just want to draw attention to an important matter because we're talking technicalities. Right. This is what, okay, page 7. All right. It says that, and I'll read in part. This dealing with certiorari. It says that, additionally, it is not concerned, that is certiorari, is not concerned with the merits, but a complaint about jurisdiction or absence of procedural fairness, like a breach of natural justice, is enough. Okay? Now, you see, sometimes we get burdened when issues of technicality. Why is somebody raising issue of law? Why is somebody pushing everybody to comply? Why is somebody asking questions? I am saying that relative to the issue at hand, I'm just trying to tell you that if a high court, for instance, errs in procedure and makes an order, that order can be quashed merely because the court did not follow certain procedures. And it's a matter of law. Supreme Court in plethora of cases have come to that conclusion, which we all know. Nobody for a moment should think that Parliament, perhaps led by the minority, wants to delay this bill. I want that to be clear over and over again. All we've asked is that, can we get the AG's handing over notes? Can we be sure of these things being captured? If they have been captured, we proceed, that's all. But nobody is raising technicalities.
Very basic. He keeps talking about law. I agree, we are lawyers. But you see, Parliament is not a court.
All too soon. That's
and in Parliament is master of its own rules.
Well, I've not disagreed on that.
Yes, so I'm saying
I've not
there are
disagreed on
times
that.
when we.
But today, what delayed the waiver was that, Mr. Speaker. No. I mean, because Mr. Speaker, you know the cap power. We took the cap power.
We can decide.
We took the cap power to court. We lost the case. But today, the judgment of the court was what we needed. Exactly. We needed the court. The court ruling.
Time will allow me, and I want to say thank you very much to these honorable gentlemen.
5 minutes of your time.
You see, you should give me 5 minutes of their time.
You should tell the producer that the procedure must be followed.
I have 2 lawyers here, and I'm going to start suing.
Remember, my senior was asking that, but they've always been taking 5 minutes of your time. So they should allow you 5 more minutes, so that we can do a proper conclusion.
And thank
I know you comply,
very
but
much.
they must
You see,
also
they
allow.
should.
No.